Data subjects have rights. They have now quite a few rights that have been strengthened or introduced as a result of GDPR, but they're broadly similar to what we've seen before in the Data Protection Act. The first one, and there's no real particular order, but the first one nonetheless is the right to be informed. They have the right to know who you are and what you're doing with their data, basically. It's very clearly laid out, all of the things you need to advise them about, and it does have a distinction drawn as to whether or not you get the data from them directly or whether you've got it from somebody else about them. Clearly, when you get it from them directly, they already have some chance to understand who you are and what you're doing, whereas when you get it from somebody else, you need to fill in those blanks for them. So the first one is they have a right to be informed. That's clearly going to have a big impact on contracts, privacy policies, online notifications, things like that, where you're going to need to include much of this data for data subjects to be able to get access to and understand who you are and what you're doing. Another right is the right to access data. This is something which is commonly known as a subject access request. It's when they can send in a request saying, show me all the data you've got about me. And there's much more detail about that, and it probably justifies a separate review all on its own. Suffice it to say, there's one or two important changes coming about as a result of GDPR. You have slightly less time than you used to. You only have a month to be able to, normally anyway, to deliver the subject access request response. Historically, you used to also be able to charge. It wasn't a particularly big charge. Most companies didn't charge, and if they did, it was £5 or £10. Now, unfortunately, you don't have that. Now, in itself, that isn't necessarily a problem. As I say, most companies didn't charge in the first place. What it did do, though, is it put some people off from doing a subject access request where they were frivolous. They didn't particularly care. They didn't particularly mind. They were just interested. Well, now it's free, so those people won't have that reason to hold back. In fact, I'd also say that there's scope now for people to be not just frivolous, but actually potentially naughty by deliberately sending in a subject access request just to give you some hassle. Nonetheless, you've still only got a month normally to be able to respond to that, and so you do need to make sure that your systems are quick and easy enough for you, staff and so on to be able to pull the data out in a hurry without it grinding your company to a halt. The next right would be the right of data rectification. The right of data rectification is basically correcting things that are wrong. So they may come to be aware, perhaps through a subject access request, about data you have about them, and they have the right to be able to say, fix that, get that bit corrected. In fact, there's a degree of obligation on you to anyway go out of your way to keep the data accurate and to try and make sure that it accurately represents the data subject, rather than just relying on them correcting it. But they do have the right to rectify it themselves. They also have the right to object. To object is basically to say they don't like you processing their data and they want you to stop. You don't necessarily have to do so, but you probably would need to be prepared to have an argument with them about whether or not your right to process their data outweighs their right to object and for you to stop. Certainly for purposes like marketing, your right definitely won't outweigh their right. If they say stop, you must stop. Similarly, I think for most commercial activities, if you're processing on the basis that you have a legitimate interest, I think that will be outweighed by nearly all objections from data subjects. There's a slightly interesting one called the right to data portability. Data portability is designed to try and allow increased competition, particularly in the digital marketplace, so online ordering and things, so that somebody might, for instance, gain access to all of their data as a result of having done business with you. So perhaps if you've been supplying them with banking services or electrical services or something like that, then they can pull all of that data out of your system and put it into the hands of their new provider or the person they want to quote for being their new provider in the future. There will be further guidance, I'm sure, coming along on that in due course, and I suspect it will be being embraced on an industry by industry basis. The next right would be the right to erasure. The right to erasure is something which for a little while was being touted around as being called the right to be forgotten, but I think that sounded just a little bit too ethereal. So it's in there as the right to erasure. Basically, it means the right to be deleted, the right to get their name out of your systems if that's what they're trying to do. Again, this is another one of those rights, as most of these are. It's not an absolute right. You might be in a position where somebody asks you to delete them and you think that's not appropriate, it's not acceptable. Perhaps you're looking after records about their creditworthiness that they'd rather you didn't talk about, but nonetheless, it is a valid thing and it's part and parcel of your legitimate interest. They also have the right to restrict processing. Now this is rather like objecting. They're saying please stop using it, but in the case of restricting processing, they're basically saying stop for now whilst we all figure out what's going on. So it's much harder for you to justify continuing processing the data if they've asked you to just sit on your hands for a few days whilst they and you can discuss what's being done with the data, whether the data's accurate and so on. So it's the right to temporarily cease processing of the data whilst everybody finds an accord. And then finally, there is the right, or a variety of rights around automated decision making and profiling. It's the right for them to not be subject to fully automated decision making. Now the actual implications of that will vary depending on your specific circumstance, but it's likely to mean that if you, for instance, are turning somebody down for a loan or telling them their insurance is going to be a lot more, and they disagree with that or they think that feels unfair, that basically they definitely will need to have the right to speak to a person about that so that they can explain on what grounds that didn't seem properly reasonable. I can't tell you what the specific circumstance might be. The likelihood is, I think as we all know, that the person they're then speaking to will then key in the extra information into their computer and the computer will still provide the answer and the person will read it out. But it does at least mean they had the chance to interact with a human and have that human influence over whether or not the original decision or profile was correct. So those are the main rights. There's quite a few of those that need further detail, specific detail. I'm going to come back to one or two, most notably subject access requests, which I think is something that we all need to get our heads around to make sure that we're on top of it before they start flooding through the door. But that's it for now.